Good evening and welcome to Courts Today by Livelaw. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. Starting with an update from the Punjab and Haryana High Court. The High Court today declared that 75% reservation for locals in Haryana in the private sector jobs having a monthly salary of less than 30,000 rupees is unconstitutional. The bench of Justice G.S. Sandhyawalia and Justice Harpreet Kaur Jeevan said that the Haryana State Employment of Local Candidates Act of 2020 is unconstitutional and violative of the Part 3 of Constitution. While allowing the batch of petitions challenging the law providing 75% reservations to the locals, the court has set aside the act. This act was introduced in the State Assembly in the year 2020 with the background that influx of large number of migrants competing for low-paid jobs placed a significant impact on local infrastructure and housing and led to proliferation of slums, further leading to environmental and health issues. Therefore, the Act aimed at giving preference to local candidates in low-paid jobs would be socially, economically, and environmentally desirable and in the interest of general public. The order was reserved on 19th October in the matter and was pronounced today. And now an update on the archaeological survey of Gyanvapi Mosque in Varanasi. The Archaeological Survey of India has filed an application before the Varanasi District Court seeking a further 15 days to file the report pertaining to Gyanvapi Mosque survey. Earlier, the court had asked it to submit its survey report by today, that is November 17th. In the application filed before the district judge, the ASI has stated that it has prepared a detailed report covering every aspect of the survey and its report is near completion and only preparation of the report conducted by the GPR is under process. In view of this, the ASI has sought a further 15 days to submit the report. You already know that last month the ASI had informed the court that it had completed the survey to determine if the mosque was constructed over a pre-existing structure of a Hindu temple or not. The Delhi High Court today pulled up the Municipal Corporation of Delhi for its failure to take possession of a public park near city's Jama Masjid, observing that a statutory authority cannot lose possession of a public park. A division bench of Acting Chief Justice Manmohan and Justice Mini Pushkarna was hearing a plea concerning the issue of possession of two public parks near Jama Masjid, which are originally managed by the MCD. The counsel appearing on behalf of MCD informed the court that the Jama Masjid authorities were allegedly in illegal possession and had locked the park, that the MCD officials were not allowed to enter the park, and that the Delhi Waqf Board was also claiming possession of the park. However, no counsel appeared today on behalf of the board. In April last year, the court had impleaded the Delhi Waqf Board as a party to the petition, as it was the MCD's case that the gates of two parks were being managed by the board. The court had also ordered removal of encroachments from the parks in the meanwhile. The bench expressed displeasure today over the situation and directed the MCD to take appropriate steps to take possession of the public park. The court also said that police assistance, if required by the MCD, shall also be provided to the statutory authority. In an important update, the Madras High Court has ruled in favor of granting incentive marks for medical practitioners and PG doctors who were engaged in COVID-19 duty in government hospitals. The bench of Chief Justice S.V. Gangapurwala and Justice Bharat Chakrabarti was hearing the pleas filed by applicants who had participated in the recruitment to the post of assistant surgeon. The challenge was against the government order issued by the Tamil Nadu government granting incentives to those health professionals who worked for COVID-19 related duties in regular government appointments. The private doctors who had participated in the recruitment process challenged this government order, contending that the rules of the game could not be changed in the course of the game. It was submitted that the examinations were already over and the results were partly declared. Thus, changing the rules for the present selection was arbitrary. On behalf of the postgraduate students, it was submitted that more patients were treated by the postgraduate students and they underwent the same trauma and risk and put in the same selfless service as that of medical officers. The state, however, objected to the plea by submitting that there was no alteration of eligibility criteria or selection process. The state also submitted that there was an intelligible differentia in leaving out the private doctors, as 84% of the COVID patients were treated in government hospitals. Eventually, the court observed that the normal rule of not changing the rules of the game during the course of the game required a different consideration in view of the COVID-19 scenario and could not come in the way of granting incentive marks to medical officers who put their life at risk. Noting that the grant of incentives was a part of the merit of the candidates, the court observed that the grant of incentives after the notification and examination was not bad in law. The Bombay High Court has refused to stay the OTT release of web series Railway Men: The Untold Story of Bhopal 1984, inspired by events around the Bhopal gas tragedy. The court has dismissed appeals filed by two convicts who were former employees of Union Carbide India Private Limited. The duo approached the High Court in two separate petitions against orders of the City Civil Court refusing ad interim relief to them. They sought a pre-screening of the web series, citing certain factual errors in the trailer and a stay on the release. As you know that in December 1984, 45 tons of lethal methyl isocyanide gas escaped from US-based Union Carbide's subsidiary in Bhopal, killing over 3,500 people within days and at least 15,000 people over the years. Investigations found that substandard operating and safety procedures at the understaffed plant led to the catastrophe. The bench of Justice Arif S. Doctor said that the Bhopal gas tragedy was the most terrible and unfortunate event which made headlines and continued to remain in the news not only nationally but also internationally for several years. The court observed that there was a disclaimer at the beginning of the film stating it was a work of fiction and only inspired by tragedy, and that there was a delay in approaching the court as well. The series produced by Yash Raj Films is set for release tomorrow. The Supreme Court has held that a writ petition against an award passed by a facilitation council under the Micro, Small and Medium Enterprises Development Act, that is MSMED Act, is not maintainable. This case relates to the challenge of an award of a Micro and Small Enterprises Facilitation Council involving a company governed by MSMED Act. The award passed by the council was set aside by a single judge of the High Court of Telangana on the ground that the claim was barred by limitation. However, this order was reversed by a division bench of the High Court, saying that the petition challenging the award was not maintainable as the appellant should have pursued remedies under the Arbitration and Conciliation Act. Against this order of the High Court, the Supreme Court was then approached. The Supreme Court bench, comprising CJI Chandrachud, Justice J.B. Pardewala, and Justice Manoj Mishra, held that the correct remedy against an award under the Act was provided under Section 34 of the Arbitration and Conciliation Act, and approaching a High Court instead of pursuing the said remedy would not be permissible. Further, the court found that as per Section 19 of the MSMED Act, an application for setting aside an award of the Facilitation Council could not be entertained by any court unless the appellant has deposited 75% of the amount. The court explained that the same had been introduced as a measure of security for enterprises for whom a special provision was made in the MSMED Act. The Supreme Court has admitted an SLP filed against the judgment of Bombay High Court, which struck down Rule 6.1 of the Consumer Protection Rules of 2020. The quashed rule prescribed two members from the state bureaucracy and only one member from the judiciary on the selection committee that recommends appointment of president and member judges to the State Consumer Commission and the District Consumer Fora. The High Court said that the rule diluted the involvement of judiciary in the selection process. The High Court also set aside appointments to the consumer fora made by the Maharashtra government on the ground that it was done in deviation from the directions passed by the apex court earlier. Before the Supreme Court bench comprising CJI Chandrachud, Justices J.B. Pardewala and Manoj Mishra, the petitioners raised two primary points. Firstly, the interviews are preceded by a written examination which has to be cleared by all candidates. And secondly, unlike other tribunals where state is involved as a party in consumer forum, cases usually involve private individuals. Thus, state has no interest in the outcome of litigation as compared to cases in other tribunals. The bench posted the matter to 24th November, saying that the issues raised by the petitioners would require further deliberation. I hope you found this video informative and enjoyable. If you did, please consider giving it a thumbs up and sharing it with your friends. Don't forget to subscribe and hit that notification bell so that you don't miss any of our future content. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.